SJC-12715, Commonwealth v. SEL Billingslea.
Mr. Campbell, good morning.
Good morning. May it please the court, my name is Alan Campbell. It's my privilege to represent S.E. Billingslea in his direct appeal, challenging convictions for, among others, aggravated rape and habitual offender enhancements. There are numerous issues raised in the brief, and it is highly unlikely that I'll get to all of them. Excuse me. I'd like to start with the first issue, that the court erred in failing to hold an individual voir dire on the question of whether this case involving interracial rape would in any way impact the impartiality of the jurors. And it's a black letter law that when an individual charged with an interracial rape is brought to trial, if they ask for it, they are entitled to individual voir dire on that question. And where the court fails to ask questions about interracial rape out of voir dire, this court will presume prejudice unless there's overwhelming evidence of guilt.
Wasn't that issue waived? I mean, didn't the defense attorney acquiesce to the written questionnaire?
I don't believe he did, Your Honor. If you go through the transcript, and this is actually the transcript that I had sought a stay for and was denied, I wasn't able to get it in time before I filed my brief. At the pretrial hearing at page 8 going into page 9, the court says, okay, well, we have to have a sidebar on this. And then the court says, and the SJC says, we have to have a sidebar on this, but they don't tell us exactly what we have to ask. And then the judge says something about, well, actually, I find that I get hoarse or I have a sore throat after asking a lot of questions, so why don't we have a jury questionnaire? And then there's some discussion about that. And during that discussion, defense counsel does say that he wasn't adverse to a questionnaire, and he says that he's not opposed to a questionnaire.
So I don't understand why that's a no, Justice Budd.
Because the court had just said twice, we have to have a sidebar on this issue. And then they go on to the questionnaire about other questions. There are numerous questions that are asked. This specific one has to be asked at individual voir dire. The other questions don't have to be asked during individual voir dire. They can be asked of the entire veneer, which is how
And you're saying it can't be covered under that general acquiescence by the defense attorney?
Correct.
It's a specific something that even if the defense attorney didn't want the individual questioning, he could not have had it done on the questionnaire. He would have had to do it orally.
There is a case from this court that says a written questionnaire is insufficient to address interracial questions, whether it's an interracial rape or interracial murder.
Right, you made some reference to a transcript that's missing?
The Commonwealth was able to obtain it, so I believe it has been submitted to this
So we
court.
do have it. Okay,
I believe they do have it.
And is there anywhere in the record where we have defense counsel saying, Your Honor, I'm sorry for your hoarse voice, but the law requires that that be asked orally, and I can't accept it being asked in a questionnaire?
We do not have that specific language. We do have the pretrial motion that was filed. We have the court twice saying, the SJC tells me I have to do this at sidebar. Then there's a talk of a questionnaire. It's unclear whether it's for this or for the other questions. There certainly was other questions. And then it goes on without this question being asked at individual voir dire. It certainly would have been better had it been done so.
Right, so what do we do with that? I mean, I take your point that if there had been a statement that said, Your Honor, we're entitled to the question being asked orally at sidebar, I think it's clear you'd be right. But what do we do with the fact that the defense counsel appears to be accepting of it being asked in a questionnaire as opposed to at sidebar?
Well, if you don't find that the discussion where the court says it twice that I need to do it at sidebar and the motion, defendant's motion asking for it, if you don't find that that preserves it, then unfortunately we're into substantial likelihood of a risk of miscarriage of justice. But even under that standard, I believe the defendant still prevails. This case,
And why is that? Because I think in this case, the jury did find him not guilty of certain offenses.
They did. There were 2 offenses for which the defendant was found not guilty. Assault and battery, dangerous weapon, knife, and assault with a gun. At no point did AB, and that's how I'm going to refer to the complainant, at no point did AB equivocally state that the knife touched her. And at no point did she testify that she saw the gun. So those not guilties did not require the jury to make a credibility determination of whether they believed AB or the defendant. For every conviction, every charge that they found the defendant guilty, every other one, the other 9 or 11 charges, they had to make a credibility determination. And in all of those, the credibility determination was made against the defendant. So the only acquittals were essentially there was no evidence of those 2 offenses. So the prejudice from the interracial crime, perhaps making them believe the white woman who was accusing the black man of raping her or invading her home and the other offenses, it could have impacted that decision. And just as I said, on the 2 charges for which there was an acquittal, there was no credibility determined needed because there really wasn't any evidence of those 2 offenses. And I think it's clear the reason you want the jurors to be asked the question and have to answer it verbally is because it's very easy to write no on a piece of paper. You're sitting in a room, you write no. If you ask the jurors, and this is the reason why you have voir dires, you ask questions, you get to see not only what the juror says, but how they say it. Do they hesitate?
I think we're aware of the importance of individual voir dire, and if you have a lot of issues, you should move on.
Okay,
to the
well,
next one.
yeah, I think that one's been addressed. The second issue I'd like to address is that the court erred in allowing the Commonwealth to argue consciousness of guilt, but failing to instruct on it. And again, the defendant did not request an instruction on consciousness of guilt, but he didn't have to in this case. The Commonwealth requested it. They filed a motion pre-trial, and at the charge conference, they asked the court to instruct on the full instruction of
And
consciousness
you're
of
saying
guilt.
it should have been given? You're saying the instruction should have been given?
Yes, the instruction should have been given.
Now, the defendant said anything at the trial about this? Ordinarily, the defendant would not want
He did
want
not,
it.
but under...
Ordinarily, the defendant would not want such an instruction, right?
he didn't say he didn't want it. He was silent on it.
But ordinarily, that would be true. The judge would be safe to assume that if the Commonwealth wanted it and the defendant said nothing, that the defendant really didn't want it.
On many issues, yes. Actually, the consciousness of guilt instruction is different than a lot of instructions. The court is required to give it if asked under Tony. The court should give it sua sponte if there's evidence of consciousness of guilt. That's Cruz. And even if the defendant says, Your Honor, I don't want an instruction on consciousness of guilt, the court has discretion to give it over the defendant's objection.
You're not suggesting that there's a different standard of review because the Commonwealth asked for it and it wasn't given. I mean, I understand the argument that it should have been given. You can give the instruction without putting your finger on the scale, as the judge seemed to be concerned about. And you have a situation here where on one side it's flight from the boyfriend and the other side it's flight from the police. So it's a pretty important instruction in this case. I know that's your position and it makes a lot of sense. But the fact that the prosecutor asked for it, that doesn't change our standard of review,
I'm not
does
saying
it?
it changes the standard of review. I'm saying that the Commonwealth asking for it makes it not necessary for the defendant to have objected. In the case I cite for that is Matos, where it's a case where a co-defendant had objected. That defendant didn't object, and the court said, well, you don't have to say
I
me
guess that's
too.
what I'm trying to get at. Assume, for the sake of my question, that it was error not to give the consciousness of guilt instruction in this case. What are we looking at in the record, recognizing that this is 33A? What's the standard of review?
I believe it's prejudicial error.
Why?
Because the issue was brought to the court's attention, the court decided it, and then we move on. It just is, as I said, in Matos, or actually, I don't know if it was a SJC or an appeals court case, apologize for that. The court said, where the issue has been brought to the judge's attention by a party, the other parties...
Isn't there a difference between a co-defendant bringing it to the court's attention and the opposing party bringing it to the court's attention? There's no reason for the court to...
For many issues, I would say that might well be the case, but this is an issue that the court is supposed to do it on its own. So the court's supposed to do it on its own, they're not going to do it. The Commonwealth asks for it, they're not going to do it. What's the benefit of the defendant saying, I'm not
Get
going
on
to?
the record to say I would object.
But it's already been brought
sometimes
to the court's
defensive-
attention, and the court has said, I'm not doing it.
But to be on the record that the defense objects, just for this very reason.
Right, but again,
that
under
you're having to
And
argue.
Cruz, the defendant-
sometimes your objection might sway the trial judge.
It's possible, but under Cruz, the defendant didn't have to object. The court is supposed to, whenever there's evidence of consciousness of guilt, the court is supposed to sua sponte instruct on it. That's Cruz.
but
And the court,
But the Commonwealth wants it because the Commonwealth wants the jury to know that they can infer from his flight that he had done something that was not consensual.
I
If the
actually would,
defendant had wanted it, it would have been to show that the mere fact that flight by itself does not necessarily suggest that. There could be many different
I would
reasons.
respectfully disagree with you, Justice Gantz, Chief Justice Gantz. The Commonwealth doesn't actually want the instruction. What they want is to argue that he's guilty because he fled. And Cruz, which says that the court, I believe it's Cruz, which said the court should sua sponte instruct on it, advises prosecutors to seek an instruction whenever you're going to introduce evidence.
They asked for the instruction?
I'm sorry?
They asked for the instruction, right?
They did.
So they asked for the instruction they didn't want.
Whether they actually wanted it or not is perhaps not the right word. What they actually want to do is argue that because he fled, he's guilty. That's what they're looking for. The instruction from Cruz, the instruction is actually to protect the defendant and protect convictions, which is why Cruz suggests if you introduce evidence of consciousness of guilt, you should seek the instruction. And the court was absolutely clear, or correct, to stay neutral on the question of why he was fleeing. You know, the judge isn't supposed to weigh in on issues like that, but the court really needed to offer guidance to the jurors as to what they should do with, okay, we agree that he was fleeing from the police because he thought he was guilty.
Did both sides argue their own spin on why he was
Yes,
fleeing?
the
So
defendant
Commonwealth
argued,
said-
I didn't
right.
want to see the boyfriend. Commonwealth argued, wanted to see the police. And again, the court shouldn't have invaded that and issued an expression as to what it meant. So
Should
they
there
didn't-
be a rule, you know how when you're dealing with a missing witness instruction, it can't be argued if there's no instruction? I don't know if you're aware of that rule, but there's a rule with missing.
I am aware of that, and that would be.
Should that be the rule when it's consciousness of guilt?
That certainly would be a reasonable rule, and in a case like this where it's, again, it relates to the credibility of the witness and it's really the crux of the case, yes, that would make perfect sense and it would obviate us being here, especially where the issue has been brought to the court's attention. Kamal says, I'm going to argue consciousness of guilt. The judge says, yeah, well, I'm going to stay away from that. Even though it's an important issue, I'm just going to let you handle it. The court really needed to offer guidance and tell the jurors what they should have done with it once they made the determination. And the next issue, unless there are further questions on that issue, the next issue I'd like to address, which I believe is a question of first impression, is that the court erred in not dismissing the 25B indictments. And it's the defendant's position that the two predicate offenses have to be the same offense. And in this case, they were not.
So they have to be the exact same offense. Does that make sense?
It does.
Why would that make sense? So if he does another crime of violence, another sex crime.
Well, you already have 25A, which clearly doesn't have to be the same offense. It's just two prior offenses with a sentence of 3 or more years. So you have another section, which has a different result. I don't want to say it's safe to assume, but if they have one section that does one thing, they have another section that does something else, they're doing something else, and they used a different language. They didn't use the same language. And it does make sense, because there's a long list of charges, including actually one charge, the sex for a fee under 272-53AB, which doesn't have a sentence of state time, so it can never be a predicate. So there's no reason for it to be in the statute, because it never applies, so it's actually surplusage.
Isn't it obvious that like offenses is talking about offenses from other states?
It does, but on the language of it's twice convicted of a like offense, it suggests that it's twice convicted of a like offense, not twice convicted of 2 offenses which may or may not have anything to do with the things. And this actually would have been very clear for the court, or rather the legislature, to have added some simple language in there, something to the effect of the prior convictions need not be for the same offense. They didn't add that language. It's convicted twice. And if you go through the the court and the Commonwealth's interpretation, you get some absurd results. If you're convicted twice of rape and then kidnapping, you get a sentence of 10 years. If you're convicted of kidnapping, and then rape, it's life without in prison. If you go kidnapping, rape, kidnapping, it's 10 years. So we're not talking about slight variances. We're talking about the difference between a relatively short, compared to life without prison, life in prison without parole, which is the offense for many of the offenses. Some of the other ones are 10 years, 20 years. It's a huge difference.
Okay, thank you. Ms. Langsam.
Good morning. May it please the court. My name is Jessica Langsam. I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. With respect to the consciousness of guilt instruction, the Commonwealth, as my brother just represented, requested this instruction, and when Justice Billings said, I'm not going to give the instruction, but you can argue it, the Commonwealth ended up not arguing that, although defense counsel did tell the jury that they can't use evidence of, they can't use, if they look at the flight, as evidence of the defendant's guilt. With respect to the first issue about the jury questionnaire, and again, my brother has represented the manner in which the Justice Billings had proposed the questionnaire, and also the manner in which defense counsel acquiesced to using the questionnaire. In other words, so defense counsel initially sought the questionnaire, but then was amenable to this, and in the 2 days of jury voir dire, never said anything, never asked the judge to instruct, never asked any questions himself with respect to this. This question was contained, as I've indicated in my brief, in question number 25 in the jury questionnaire, which is at the Commonwealth Supplemental Record Appendix, I believe at page 78. So this met the statutory requirements of 234, section 28. And with respect to whether or not the defendant...
Is that right? Are you saying it's not error to have that question be asked? I'm sorry, let me rephrase. Are you saying that it's permissible for a judge to ask that question in a questionnaire as opposed to at sidebar?
Your Honor, I know that Commonwealth versus Young and Sanders, the interracial rape, the interracial murder, and most recently Cologne say that the question has to be asked, but it's only upon the defendant's request. And here, where the defendant initially requested it, but then really withdrew that request by saying he wasn't averse to the questionnaire and going along with the procedure in the 2 days of attorney-conducted voir dire, even if the judge should have orally asked the question, there's no indication that the defendant here was prejudiced. This was a case where there was overwhelming evidence presented as to this crime. The victim never identified the defendant.
Let's divide the issue of error versus, or waiver versus prejudice. So you agree that if the defendant had said, no, Your Honor, I'm entitled to the question being asked orally at sidebar, the defendant would be right?
Yes, Your Honor.
So then the question is whether or not, and the defendant initially made that request, I gather.
Yes.
So now the question is whether or not the defendant essentially relinquished that request or waived it because of the questionnaire.
Yes.
Okay, and so, all right, but if the defendant had not waived it, what do you think would be the standard of review?
If the defendant had not waived it, this is not a constitutional question because the asking of the question is pursuant to this court's superintendent's power. I know that's set out in DeRusso and in other cases. So then it would be prejudicial error, and that the defendant here is not prejudiced for the reasons that I've just explained to the court. That there is no indication that the jury improperly considered race in reaching a verdict, partially for the reasons that my brother mentioned, which is the fact that the jury fairly weighed the evidence is plain, where they acquitted him of 2 of the counts, and my brother's recitation of the facts underlying those is not entirely correct. There was evidence of the assault with a dangerous weapon, which was count 8 with a gun. The victim had testified that she thought the defendant was holding a gun to her head while she was on the phone with her boyfriend, John. And the ABDW knife, which was indictment number 6, the evidence of that was that as the victim was looking down from her blindfold as she was bleeding and naked, being pushed or led down the basement stairs by the defendant, she looked down through the blindfold and she saw him holding a long, slender knife against her thigh. That knife did not belong to her. She also testified that in some point during this hour-and-a-half long assault against her, she was cut on her torso. So I would just wanted to set the record straight with respect to that.
If I could turn you to an issue which your brother has not addressed.
Yes.
Which is, we, of course, will decide this case. The question is, are we obliged to decide all such cases for a violation of this statute, or is this something for which the appeals court has concurrent jurisdiction?
And I know that that's the reason this court took the case, which was originally entered in the appeals court, and that Barbosa, the court, didn't reach it. And I would submit to this court that reading the 2012 amendments to 27925B in context. So at the time that the legislature amended the statute and amended 33E to make a third conviction under 27925B a capital case, it appears from the plain language that the legislature included all 25B convictions, but that doesn't make sense because the legislature presumably was aware at the time of the amendments that only convictions of first-degree murder are reviewed by this court under the intense scrutiny of 33E standard, which is, as this court is more aware than I am, the whole case for consideration of the law and the evidence due to the nature of the crime and the severity of the consequences. So it must be, also considering that of the 40 or 41 enumerated crimes in 25B, only 17 of them have a life, by my count, have a maximum sentence of life in prison, and 23 do not. So it reading, I guess not between the lines, but reading the amendments in context, it seems plain to me that that's what the legislature's intent was. And
But
that
what happens if it actually is a life without parole sentence and arguably falls within capital? How do we, and so plenary review,
Yes.
how do we deal with that's exclusive jurisdiction within the SJC and not considering Chapter 211A, Section 10, giving concurrent jurisdiction to all but murder?
And I'm sorry, Your Honor, so the question is, it would be my understanding then, if the defendant is convicted under 27925B and he's sentenced to a term of life in prison, then that case would enter directly in this court.
Life without parole.
Yes, Your Honor, and that all other cases would enter in the appeals court pursuant to 211A, Section 10.
So whenever a judge gives a sentence of life without parole, then we're gonna take it and apply 33E to it?
That would make sense, Your Honor, as the harshest punishment in the Commonwealth and consistent with this court's same scrutiny for that level of punishment for convictions of murder in the first degree, that case should have this level of
But
scrutiny.
33 is amended recognizing that 211A, Section 10 exists, which gives concurrent jurisdiction to the appeals court in all situations but murder, right? So, I mean, you know, it doesn't make sense, really. It's one or the other. It's not sort of a hybrid,
Yes, yes, Your Honor.
right? I mean, isn't it one or the other, the sort of hybrid, well, if it's life without parole, you know, that's just a compromise with legislative language that doesn't really exist.
Well, Your Honor is correct. It doesn't really exist. In reading the statutes as a whole, and in reading the recent opinions of Garvey and Ruiz that Your Honor Justice Budd has written with respect to 25A and 25B, that's the Commonwealth's position insofar as just reading all the statutes in context that this court should look at those 25B convictions of life with the same level of scrutiny as the first-degree murder conviction.
Counsel, does the language of a capital case come into play here? Does a capital case, it didn't always just mean murder, correct?
Yes, yes, Your Honor.
So would that give us illuminate anything in terms of how to analyze these statutes?
Well, I think this is confusing because, say, 263 Section 6 was not amended. I thought about this with respect to whether or not the defendant can elect a bench trial with respect to the subsequent portion, the criminal habitual offender portion. And the case law, which is still good in the line of cases, which is O'Brien and Francis, and then Commonwealth versus Waweru, which touched on this, is that 233E defines what a capital case is. I know there's also a definition of a capital crime in Rule of Criminal Procedure 2, but 233E defines what's a capital case for purposes of the underlying trial. And so 236 Section 6 says you can't waive a jury trial for a capital case. The manner in which this case was conducted, the defendant had, I think at the beginning, 14 peremptory challenges. So this was given, the defendant had this full panoply of rights that you would have as if a capital case was being tried. And actually, the judge then upped that to 16, because I think there were concerns about the case going over a long weekend, and that we were worried, I was one of the trial attorneys in this case, that we might lose some jurors.
So you're agreeing we should do 33E review in this case?
I beg your pardon, Your Honor?
You're agreeing we should do 33E review in this case?
Yes, I am, Your Honor.
Okay.
Yes.
With that in mind, I know that the defendant did not raise this, but how about the problem that might arise as a result of the 2012 date for the amendments and the use of prior convictions as to establish habitual offender status? Is that not an ex post facto problem?
That going forward, if the defendant hadn't been warned at the prior time that his convictions could be used as he was climbing the ladder to reach this habitual offender, I hesitate to weigh in on that, not having.
I know it's a surprise, but I mean, if you're agreeing that 33E review is part of what we have to do, we have to do issues even if the defendant didn't raise them.
And I can't recall if it's Garvey or if it's Ruiz or. My recollection is that this court has addressed that issue insofar as saying that if the warnings are not given, that doesn't mean the Commonwealth can't go.
Would you like the opportunity to do a letter on this?
I would, Your
question?
Honor, thank you.
Okay.
Yes.
And you may too.
I'm
I think.
confused.
Is that right, Chief?
Oh, sorry.
Is that right?
If Justice Link wants a letter, then Justice Link gets a letter.
I'm confused. You want us to basically give trial judges the decision of whether something goes directly here or not based on their sentence, as opposed to a particular crime? I mean, it just seems odd to do that. Is there, right?
Well, no, Your Honor. It's not that trial judges have the discretion. The Commonwealth indicts the defendant with these with the sentencing enhancements, as we did here, for habitual criminal and habitual offender. I know that my brother raises this issue about Richardson and Boyd, and that we shouldn't have filed the null pros, and there's an Article 30 problem, which I argue in my brief that there's not. And then we properly null prosted under Richardson, and then the judge sentences the defendant, as he must, to this maximum term of life without.
I guess I got confused. You say 17 out of 41 of the particular crimes can be
Or have life as a maximum term. Life in prison is the maximum penalty.
So, but we're only going to do 33E if the judge gives the maximum.
Well, the judge is obligated to give the maximum, Your Honor. So once you've been convicted in the underlying crime of your third strike, and then we go forward on the second portion of the trial, which could be, as Your Honor, is where a new trial.
Not discretionary then.
So
Right.
let me ask you this, because we're going to be talking about this pretty soon. So assume that that 211A Section 10, the plain language of that controls.
Yes.
Is there any what's the argument? Why shouldn't the appeals court be able to do the plenary review and then deal with the gatekeeper issues on subsequent motions for new trial?
Well, I think that this is maybe a gap in the statutory language. I mean, so when the legislature amended 33E to include 25B in the definition of a capital case, and then we've seen in various other issues raised in this brief where 263(6) was not amended. So it's in looking at all of the statutes and the rules together, Your Honor, and the case law, it seems fair that when an individual receives the maximum penalty in the punishment in the Commonwealth, since there's no longer execution, that the case goes straight to this court for review.
So is that a matter of common law, superintendence, or statutory interpretation by you?
I think it's, well, I think it's a matter of statutory interpretation. And I mean, I know that, well, this is the first case that's come up with respect to this issue, so I know that this is this issue that the
And
court's
the
concerned
rule
about.
would not apply if a judge gave a basketball score and gave someone 60 to 70, right?
That's right, Your Honor. No, it would not, but the judge is required to impose the maximum penalty. And I would just argue that with respect to this court's 33E review of this case, that was, the sentence that was imposed in this case was fair and was consonant with justice, where this is an individual who had previously convicted these two other crimes, which the Commonwealth proved in the subsequent offense portion of the trial. And given the facts of this case and the fact that the defendant's arguments here lack merit. I'd ask the court to affirm the convictions here.
And what is our role with regard to a 33E review in terms of whether it's consonant with justice? Do we have the ability to say that even though it fits within the confines of the statute, it's not an appropriate case because it's not consonant with justice?
And Your Honor is referring to, well,
I mean, I understand this is a particularly horrendous rape. Not that there's anything, not that there's a rape, but this with the combination of violence and the I mean, this one was, this is certainly in terms of the realm of horrendous. But let's imagine we had something less serious. Would we have the ability to say that life without parole is not consonant with justice, even though it fits within the confines of the statute?
well, and I was thinking about that question, and it seems that a 25, there is no lesser, well, 25B is a sentencing enhancement, it's not a crime. So there's no lesser included. Like 25A is not a lesser included. So even if you looked at sentencing enhancement under, say, Blockberger or Morey versus Commonwealth, it's not a cognate offense. So there's no lesser verdict. It's not like a first-degree murder case where this court can reduce the verdict and then remand for resentencing. I don't know, I might suggest to the court, but I don't know if in the court's superintendent's power, perhaps imposition of remanding for imposition of a lesser sentence if the court concluded that a sentence of life in this particular case wasn't consonant with justice.
So, I mean, the complicated element is that if it is murder in the first degree, we do have the ability to reduce it to a lesser degree of murder.
Yes.
Are you saying that we don't have that same authority when it's not murder, but a violation of 25B?
Well, I'm not saying that the court doesn't have that authority. I'm saying that 25B doesn't have a lesser included, unless the court, I suppose, looked to the crimes underlying in the substantive offense. There is no lesser included crime of 25B. And that's why, so 25A says any felony. 25B has a specific list of felonies. 25B says no reduced on parole or probation. So each has an element, as it were, that the other does not.
But isn't that the wrong question? I mean, the question is, well, when the legislature said plenary review under 33E, the legislature understands the ability to reduce the charge, well aware that there are also mandatory minimums.
Yes, and I think this is, as noted before in different issues that have that are in this appeal, the manner in which the legislature made these amendments, where perhaps the legislature could have been more specific with respect to the 2012 amendment to 33E as to exactly which cases the legislature intended would have this court's direct review. I think there's something missing.
Right, I guess going back to your point earlier, is 25A a lesser included of 25B, or is it separate and distinct?
No, Your Honor, it's something distinct. And again, saying like even if these are crimes and not sentencing enhancements, they each have an element that the other does not. So that's why I would submit that it can't be, this court can't say that it's a 25.
And I assume your argument is that even if we do have that authority, we should not exercise it here.
Exactly, Your Honor.
Okay, thank you.
Thank you, Your Honor.